The Open Society Foundation is always delighted to co-host events with the American Constitution Society. And on behalf of our two organizations, I would like to welcome you to what promises to be a riveting morning as we seek to invigorate the constitutional pardon power and explore whether the president has a role in making drug sentences fairer, including an intriguing process through which that can be used. Examine allegations of discriminatory treatment in pardon recommendations. Discuss ways to level the odds for clemency applicants through the institution of law school clinics. Hear how the pardon power has been exercised in a state. Hear from a family member about the president's first commutation. And as all, stress the importance, again, of reinvigorating and revitalizing the executive power of clemency. So with that, I'd like to bring to the podium my colleague, Kanya Bennett, Director of Programs for Criminal and Civil Justice for the American Constitution Society for Law and Policy. Kanya.
Good morning. Again, welcome to today's event, Reimagining the Constitutional Pardon Power. Does the President have a role in making drug sentences fairer? I am Kanya Bennett, the Director of Programs for Criminal and Civil Justice at the American Constitution Society for Law and Policy, otherwise known as ACS. For those who are not familiar with ACS, we are a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debates on vitally important legal and constitutional issues through the development and promotion of high-impact ideas. If you support these efforts and are not yet a formal part of our network, I encourage you to become a member of ACS today. This morning's conversation will be a continuation of ACS programming that is generated out of our Criminal Justice Issue Group. This issue group examines the administration of our criminal laws and the challenges that such administration poses to our nation's fundamental belief in liberty and equality. It is in this forum that ACS considers drug and sentencing policy, among other issues. It is also where ACS began exploring questions around the President's pardon power a few years ago, namely in an ACS issue brief authored by Margaret Colgate Love, who joins us today. In this brief, it was asked, how can the President most effectively use the pardon power to provoke and shape a national conversation around criminal justice policy? And now, earlier this month, at another ACS and Open Society Foundation's program, the question came up, should the pardon power be used to correct the sentencing laws of the failed war on drugs? Today we will explore both of these questions and others, and we are pleased to be joined by Congressman Bobby Scott, who will offer brief remarks at this time. Congressman Scott represents Virginia's 3rd Congressional District and is serving his 10th term in Congress. He is the ranking member of the U.S. House Judiciary Subcommittee on Crime, Terrorism, and Homeland Security. We are thankful for Mr. Scott's leadership on various criminal justice issues. Please join me in welcoming Congressman Scott.
Thank you. It's certainly a pleasure to be here and to discuss the issue before us. The Open Society Foundation and the American Constitution Society for the Constitutional Society for Law and Policy have always been out front in discussing the very controversial but meaningful issues. So we want to thank you for bringing us together. The question before us, does the President have a role in making drug sentences fairer? And then references the pardon power, obviously, as a tool to use. The first thing that comes to mind is that the drug sentences should be fair to begin with. And we shouldn't need pardon power to try to make them fair. They ought to be fair to begin with. And that would mean, obviously, to get rid of all the mandatory minimums, get rid of all the super enhancements and other things that add to the sentences without any individualized consideration. But we unfortunately are in a situation where we're not getting rid of mandatory minimums. Just yesterday in the Judiciary Committee, we reported some new ones. I say if you want to get rid of mandatory minimums, the first thing you have to do is stop passing new ones. Well, yesterday we started to pass some new ones. The pardon power should be used only, not in a general sense as part of the process, but only ought to be used in extraordinary situations where a person has been rehabilitated or transformed, or other extraordinary situations, not part of the routine system. We've seen how mandatory minimums can distort sentencing. I have a constituent in my district, Kimber Smith, which I'm sure most of the people here are familiar with. She was a college student. Her boyfriend was dealing drugs, and she probably broke the law somewhere along the lines of you take a message or you drive somebody somewhere, you're part of the conspiracy. And so she got roped in. Her boyfriend got killed in a shootout with police, so there she was. No information, no anything else to reduce the sentence. And she got charged with his drug conspiracy, and you look up on the chart to see what the weight of the drugs he was dealing gives her, and it's 24 and a half years. The judge had no discretion. She wasn't dealing, she wasn't using, her boyfriend was doing all that, and she got saddled with a 24 and a half year sentence. Fortunately, after 7 years, President Clinton used his commutation power, and after 7 years, she was released. That was in the year 2000. Since then, she has graduated from college, married, raising her children. She's now an author, a lecturer, a consultant on criminal justice policy. Obviously, a much better result than having her serve 12 additional years. She would still be in jail today, with the taxpayer footing a bill for $300,000 for which they get no criminal justice benefit. But that's, it's cases like Kimba's that point out to us the insanity of mandatory minimums. The low-level people get too much, the worst offenders often don't get enough. It's bound to be discriminatory, waste of taxpayers' money. It transfers the sentencing decision not from the judge in a transparent, open process, but by the prosecutor. When he issues the charge, he's also issuing the sentence. We find that many of these mandatory minimums just violate common sense, but because they're mandatory, the judge has no discretion but to impose that sentence. But we are where we are, and the president can obviously make a difference. Fairness and sentencing ought not really be part of the pardon process, or not be part of that process, because by its very nature, it's a political process. And fairness in sentencing should not depend on politics. And the president has to consider the political implications of issuing a pardon. He has to consider whether this defendant, not whether he's entitled to it, but whether he's deserving of it. And that has political implications. When is the next election? And how does this pardon fit into my campaign message? Those are not issues for which a defendant with constitutional rights ought to be subjective. That's subjective. We also have a situation where they've been counting the pardons, and there appears to be a discriminatory pattern, and that's going to be addressed today later by some of the panelists. And so, fairness in sentencing should not be based on politics. It ought to be based on the law. But until we fix the mandatory minimums and the other slogans and sound bites that have gotten us to the situation where we lock up a higher portion of our population than any country on earth by far, the pardon process has to be part of that process. Hopefully we can fix the criminal justice system, but in the meanwhile, we'll be reviewing today how the presidential pardon power can make a bad situation less worse. Thank you very much for the opportunity to be with you, and I'll have staff people here reporting back as to what happened during the proceedings. But thank you for this important conference. Thank you. And I also want to welcome a former colleague. We worked together on a number of things, Bob Ehrlich, who's left Congress, had a distinguished career, and it's good to see you again, Bob. Thank you.
Thank you for those comments, Congressman Scott. We look forward to working with you on these issues. To continue this conversation, we are pleased to have with us the Honorable Robert Ehrlich. Mr. Ehrlich served as the 60th Governor of Maryland from 2003 until 2007. Prior to serving as governor, Mr. Ehrlich represented Maryland's 2nd District in the U.S. House of Representatives and Maryland's 10th District in the State House of Delegates. Mr. Ehrlich currently serves as senior counsel at King and Spalding. While governor, Mr. Ehrlich granted clemency to over 200 people. He will soon launch the nation's first law school clinic devoted to pardons. Please join me in welcoming the Honorable Bob Ehrlich.
Hello, everybody. It's great to see my old friend Bobby. He's not aging. We're both aging. This is a great opportunity to talk to some young people about a really important subject. I brought Greg Masoni, who I'm going to get to in a second, my former press secretary with me, my aide Patrick Mulford. I'll get to the guy in the middle in a second because he played a role in this process, sometimes unwillingly as press secretary. We'll get to that aspect of pardon and commutations in a second. Real briefly, I'm going to take some questions after I speak, but I'm going to really talk about two issues. One is process, sort of the 4 elements that I view from the state level as essential to the criminal justice process with regard to pardons and commutations. And then 10 observations for your consumption. 10 observations to take away from my experience as a legislator at state level, federal level, but most particularly as governor of the state of Maryland, very active in this particular area. With regard to process, Maryland had a very clear process. It was simply that my predecessors, and unfortunately my successor, do not have much interest in it. Parole board approvals went to the governor, and traditionally that's where they died in the past. When we came in office, we said, all right, we'll take parole board approvals and we'll set up our own process. We'll do pardons, we'll do commutations, we'll have a very objective process. And that's one point, obviously, that with regard to politics, and Bobby talked about the politics a little bit here, when you establish order, when you establish regular order, you tend to keep bad reporters, present company excepted, away. You tend to keep bad press reports away. Victim notification, an essential element if you're going to take this process seriously. Victim and prosecutor's right to be heard. Typically, when we were going to give a fairly extraordinary remedy, commuting a lifer sentence, for example, not simply some minor pardon from an offense 30 years ago, we would interview all parties involved, including the judge, including the prosecutor. One thing you have to realize here, prosecutors typically don't like what you're doing as an executive because you are reopening their work. And typically there's a lot of pushback from prosecutors at all levels of government. Published notices of decision were law in the state of Maryland. Last minute, leaving office, voluminous pardons, beg bad press. You're asking for bad press. Conversely, regular process begun early on in your term, where it's almost expected by the media, whether it's monthly, quarterly, bi-yearly, whatever process you want to set up, tends to minimize any potential bad press. Communication is the second element. That's why I'm happy Greg is here today. I'm a Republican, so it was somewhat counterintuitive for the press to see me, a Republican governor, so proactive in this area. A little bit of Nixon goes to China syndrome here, and that's how the press interpreted it. But any member of the press that interpreted it as such had not followed my career, certainly not followed my campaign. I actually campaigned on this issue. Now, when I talked about it on the campaign stuff from Congress going back to governor, my staff would say, nobody cares. Why are you doing this? That was you, actually. And Greg was right. Nobody cared. It was some guy running for, they knew who I was, obviously, running for governor, talking about an issue that was not a hot burner issue. They wanted me to talk about dollars and cents and budget deficits and tort reform and everything else the governors engage in. Not this. But I wanted to plant the seeds in the campaign because I knew what we were going to do once we won. So once those seeds were planted, it was relatively easy to go back and remind, particularly the press, that this is what I talked about during the context of the campaign. This is my promise. This was my campaign promise. And guess what? We're going to do it. So Communication is pretty important here. I saw as part of my job description, and as an attorney, and marrying a public defender and a subsequent prosecutor, this is an issue that we talked about at home with my wife. So I viewed it as an essential part of the job description. It wasn't extraordinary, it wasn't political, it was just simply an element that went along with the job. However, we deal in the realm of politics and the press and the media, and particularly in Maryland, as Republican governor, fairly hostile media. So, as we went about this process, we realized that a media strategy was also important. And as a result, whenever an innocence pardon occurred, we tend to give it a great deal of attention. Innocence pardon, obviously, being a typical case scenario where someone has served a long jail sentence, somewhere along the lines after 10, 20, 30 years, exculpatory evidence came to light. Literally, the person was proven innocent after serving a lot of time. In Maryland, the Board of Public Works, part of its job description is to give dollar awards to people, relatively few people, obviously, who fall in that category. Well, think about if I took you out here and locked you up for 10 minutes, an hour, a day, a week, a month, a year, quantify that time, and you're innocent. You tell me what it's worth. There's literally any dollar figure that would come to mind would make sense. It's an unquantifiable exercise, but it's something that governors do, and the Board of Public Works does in the state of Maryland. We would tend to take those situations and explain to people what the pardon process was in a very easy context. Nobody's going to oppose the innocent one, obviously. The person's been proven innocent. An observation, particularly for the young people here, you may not get this. You may not go back to midnight basketball with Bill Clinton or the Willie Hortonization of this whole process with Al Gore and clearly in American politics in the 80s and 90s, during my time in public office in state legislature and Congress, this was radioactive. This was seen as the third rail. Don't get into it. More conservative audiences particularly don't want to hear it. My observation over the years, however, was somewhat to the contrary. It was because the criminal justice process has touched so many lives in this country, because of mandatory sentences, some of the issues that Bobby talked about, because so many young people particularly have been impacted, or their friends or their relatives have been impacted by this process, in many cases in an unfair way, the radioactivity attached to it was no longer terribly relevant. It's still there. There's a fear factor. But the lines we drew in the past were slowly disappearing. That it was more safe to talk about this issue and what we were doing and how proactive we were with very conservative audiences. And the pushback wouldn't be there. And that was my experience. That was my experience as governor and as a member of Congress. I would also add this, and it's part substance, it's part political. If you're going to do this as governor, or as president, quite frankly, it'd be very helpful to get support from victims' rights advocates, and I had that in the state of Maryland. The lead person with regard to victims' rights in the state of Maryland was quoted positively with regard to my process. That immediately took away some of the potential vitriol that could have been coming our way as a result of following this process. For investigation, the old cliche about leadership is true. If everything's a priority, nothing's a priority. Your staff needs to understand what your priorities are. When I came into office, my legal counsel was 5.5 people, 5 full-time, 1 half-time. I said, look, this is the priority, we're going to do it, we're going to revisit cases, it's time intensive, it's part of what I want to do, and we're going to do it. 2.5 people in my office did this full time. So, if I would have had half a person, 1.5 folks, you would question whether it's a priority. You can talk about being a priority, but the caseload was so dramatic, you have to back up your words with deeds. My staff fully understood this was a priority. Is that fair, Greg?
Monthly meetings.
So you make it a priority, you use common sense, and again, you understand that prosecutors particularly, and some judges, will resist the process. They're not going to welcome the call from Ehrlich's staff about a case that's 20 years old. That's cold. That's done. What? Governor wants to what? And I got some real pushback from the prosecutors along the way in that regard. Now, the other thing with regard to process, you not only set up the process, but you also place markers. And I had relatively very few markers. It was basically whatever cases came our way, we would look at. If I thought there was some merit attached to the case, you assign your folks. My one marker was, what, Peter?
If you owed money for child support.
Okay, child support arrears. That was my marker. If you're coming to the governor for an extraordinary remedy and you're behind your child support and can't take care of your kids, I'm not going to talk to you. Even when a meritorious claim. Just not going to talk to you. And my staff understood that. So they didn't bother me with even, merit-based claims if the person happened. Now, obviously, we're talking about pardon cases, not commutation cases here. But that was my marker, and I made it well known to everyone within my group. Briefly, 10 observations for your consumption. 1, friendships will be tested. One of my great friends in the world started a law firm together in Baltimore out of law school. My counsel to my campaigns. I'm godfather to his kid. Brought me a dog case, a client of his, and needed a pardon. And my staff looked at it, and the recommendation to me was, no, the guy doesn't deserve it. My buddy calls me up. Will you take another look at the case? All right, he's my friend. I'm the godfather's son. We took another look at it. It's still a dog. The answer is still no. Friendships will be tested. Secondly, inappropriate contact may occur. I'm not going to mention names to protect the guilty. But I guarantee you, if you talk to presidents, other governors, the volume of emails today, the volume of phone calls in the past, or the way out of office, will be seen to have been fairly dramatic on the high end. Lots of people want to talk to you leaving office. Lots of people want to get their buddy that pardon. Sometimes in very inappropriate ways. I was very lucky. I have a former United States attorney who had my back at all times, including the last minute leaving office, when I still had the power to sign whatever I wanted to do. It's a great way to get in trouble leaving office. It's a great way to cast all sorts of questions about your administration leaving office. It's a great way to damage your legacy leaving office. Third, your staff will be tested. My process was myself, Lieutenant Governor Michael Steele, many of you know him, and my legal staff. A bunch of lawyers in the room. And him. Because in Maryland, as I said, these were in the paper, had to be statutorily required. We knew the press was going to look at what we did with the fine-tooth comb, and we knew if it was a controversial decision, particularly a commutation, most particularly commutation of a life sentence, there would be a lot of questions. So Greg's role was to say, why are we doing this? This is a discretionary act. You're a Republican governor of Maryland, you have enough problems. Why are we causing more problems? And that was his role. And that's a very legitimate role, by the way. I overruled him, but that was his role. Fourth, your political courage quotient will be tested. And this is an interesting part of this entire process. On the left, you're not going to get a lot of credit for some reason. On the right, there's not a whole lot of interest. So if you do this, do not expect any parades. They're not going to be scheduled. Fifth, there is a fiscal impact, and Bobby referred to it, but be real careful if you're going to engage in this process. The last thing the public needs to hear out of an executive's mouth is, we're going to revisit criminal justice issues not as a function of justice, fairness, but of fiscal issues. We can't afford to lock all these people up. Well, some of these people we need to lock up. Some of these people need to be behind bars. So the last thing you want to do is you'll lose this argument. It's be seen as engaging in this process as a function of budget problems, not justice. 6, it is about doing justice. And as governor, that's the essential job description. In Maryland, it's almost unilateral. It is unilateral, quite frankly. Other states, and Margie will tell you, not so much, but governors still play a dominant role. It's a place where you can really do justice in a unilateral way. 8, and this is kind of interesting, as Bobby talked about race a little bit, I did not view this as affirmative action, set-asides, quotas, this was race neutral. It was everything neutral. Class neutral, gender neutral, ethnicity neutral. It was simply taking these cases on their merits. And the color of one's skin was not of particular interest to me. And the results were going to be the results. Now the media, and Daphne's here, you're on the panel, right? The media will report, the media will look at, obviously, results by ethnicity and race and sex and all that. So it's just something with regard to our process that it was what it was. 2 last points here. Leadership. Everybody has written a leadership book. If you go to Amazon, look at all the leadership books. It's a growth industry. Everybody wants to give their 10 elements of leadership. Well, leadership is easy to talk about, more difficult to actually implement in the real world. This, in my view, is a test of leadership. If you simply want to be a politician, it's real easy. It's a popularity contest, you get more votes on election day, and then you do what you need to do to get reelected. If you want to be a leader, you're going to do things that are more difficult, that may be unpopular, that might get you unelected. Big difference. Please be leaders, not politicians. And last, transparency. Politics is full of talk. Talk's cheap. A lot of rhetoric around politicians and campaigns. But in this particular exercise, in my view, it allows you, the voter, the observer, the pundit, to look inside of a potential leader. It's a very important part of leadership, but it's also very transparent in that sense. Because you're going to see what a person is actually about, what their priorities are. Is it speech giving or is it doing difficult things? And that's, again, a very important part of the political process for your consumption. I'll be glad to answer any questions, and I'll be on my way. Thank you very much.
Your comments and your record reflect that you're a person of strong principle and political courage. And I really appreciate that. I happen to work for a person like that. And
You do.
I wonder, though, especially when we look at it from a state perspective, since so much of this is dependent upon an individual such as yourself being in the position of governor, if all of what you said were codified in a way so that it's somewhat protected or insulated from the political process, would that be a better system, or would it be best to continue to depend on having someone such as yourself in the position to ensure the kind of considerations that you articulated?
Margie will give you the history lesson here. Clearly, the framers viewed transparency as an important part of this process. And they viewed it, again, as integral to what a president does. And I suspect a lot of folks who drafted state constitutions along the way held the same view. Your problem, as you know, is that in politics, and you live this, when you generate a different regime, a new statutory process or whatever it happens to be, and you take power from A in order to give it to B, you got a problem. Presidents, governors fight for that authority. If you're in a state where a governor, like mine, where governors traditionally are not interested in this, and well-meaning folks come to the legislature and say, hey, we want to create a new regime that takes the power away from the governor and give it to the legislature or some extraordinary body or something, and Marty can tell you all the different setups around the country, governor's going to fight that. Governor's going to protect, legislature's going to protect their autonomy. So it sounds good, and I understand where you're coming from, and I get it, and it's frustrating, like crazy. So I just think practically that's not a promising way to approach it. One of the reasons for my clinic is we would like to draw obviously attention to the issue and invite new governors. Every new elected governor we invite into the clinic. And they can do their own thing, but at least it'll be on the radar. So I think that's a more potentially practical way to move the ball down the field.
How much of educating in terms of reporters, how much do you have to actually educate the reporter about the process and even some of the legal standards in order to properly convey what you're trying to do with the facts and context, so that way the story gets out in the proper way?
Well, in our state, we had to do a lot of that because it didn't happen. So the first time we put out a list, we had to put out a list, advertise it 2 weeks prior to the order being signed. It took a lot of education, and the reporters were very interested in the process, and like from that point on, after the first group of names came out, then it was gotcha games. It was, well, why are you letting this person out? And did you talk to the victim? And did you do this? And did you do? And there was little support, as the governor said, from anybody on the left or the right in this process. So we were kind of the lone voice in making this happen. So a lot of education has to take place, and fortunately there are reporters like Taifa who have great knowledge of the issue and understanding of what's going on, and has an agenda, wants to see this move forward, and the executives do more of this. But you don't get that often with reporters. Most reporters, I think, definitely would agree, they're given an assignment and they will work toward their editor's end on what they want to see printed. So
I think that if you, again, establish a regular process, they're not thrown off, they're not surprised, they're not looking for secret agendas. It's there's a look again, another month, another list, just like last month and probably like next month. So to that extent, it's not necessarily education, but it's expectation. Reporters don't like to be surprised. If you're not surprising them, typically they won't look for poor motive.
Could you talk a little more about how you involve the victims and their families?
Yeah, I mean, obviously, if you have a fight in Ocean City when you're 17 and you're 39 years old and you need a security clearance and NSA, we're not going to go talk to the person you have to fight with. The more serious cases, crimes of violence, obviously lifer cases, you're going to do it. And it was very mixed. Sometimes, by the way, the person was deceased, you talk to the relatives. But as a lawyer, and I do believe with my legal training, I wasn't a criminal lawyer, by the way, but I think my legal training helped here. When I would review a transcript or I'd review a memo from one of my staffers, certain things smell. And if something smelled to me, it was basically, it was smoke that couldn't be fire. And if something smelled to me that, I saw a fact situation along the lines of African-American defendant, one-day trial, very questionable ID from the witness stand, co-defendants are out, this guy's not the shooter. What? And you start lining up these and race maybe played a part in a particular area of state at a particular era. So if you start, but that's only one factor of many. So if you start lining up these factors, and that's when you make the uncomfortable calls back to the judge or the prosecutor. And some of those calls got very uncomfortable. For them, not for us.
Eric Sterling from the Criminal Justice Policy Foundation. Your reference to having a clinic for governors, you didn't speak about that in your remarks. I'm interested in hearing more about that, and I'm particularly interested in whether or not you think giving a clinic for candidates for governor would be useful. That it seems to me that I did gather from your remarks that many governors have historically not been interested in this. They see it as a politically risky approach.
Yes.
You did campaign on it. It strikes me, and your point about how it protects you if you do campaign on it. It strikes me that sort of reaching out to men and women who are running in both parties for governor to talk about this power that is so infrequently addressed in campaigns would be constructive.
Yeah, let me just, a parenthetical point before I answer the question, and Margie again will tell you the history of it. Activism in this regard is very difficult to predict. Partisan identification or even philosophical identification, conservative, Republican, liberal, Democrat, very difficult to predict which governor is going to really be interested in this. Because you have a real mix. Is that fair, or is that fair? You have a real mix here. I like your idea. We're trying to stay practical. We're in the negotiating process now with some law schools. By the way, when this article first appeared, when Daphne's article about my clinic proposal first appeared in the Post, within 24 hours I had 5 phone calls, 5 different law school deans. That's how interested, at least law school deans in this area are. The problem with candidates as opposed to governors-elect is that their staff will be telling them the last thing you need to do is go to some DC area law school and talk about an issue nobody wants to talk about that could end up hurting you. So I don't think we would get a lot of interest in that regard. Once elected, however, particularly those who are lawyers, but not necessarily just lawyers, I think that's the time to strike. Anything else?
You know, I feel like you really hit the nail on the head, at least for me, on this issue of process and how important that is. Because when I think about, you know, the sort of scandals around politics and pardons, I think of the last-minute commutations and pardons by President Clinton and Hallie Barbour.
Just have a slide, hit me on the way out, right?
It also makes me think about, you know, like in George W. Bush's book, he talks about this ride he went
Yes.
on with
Yes.
President, soon to be inaugurated President Obama, and talk about this issue in the limo ride over. And he told him, you need to set up a process.
Yes.
But we really haven't seen much of a process, unfortunately.
Well, we know the guy who tried to set it up unsuccessfully, so.
Yeah, and
He's not
so
speaking today, right? He's not? Great. What grade is he?
this afternoon.
Well, the guy that tried to set it up is going to be here today, so.
Yeah, and I just really wish that this message of process and making sure it happens throughout someone's tenure while they're a governor or a president is so important. And if you could tell as many people as possible, and I know you've been doing that, I really do appreciate that. But it seems that, you know, the public will be behind this. They'll be behind commutations if there's transparency,
I
they
think so.
understand why it's happened.
I
And
agree.
it's not done, you know, in the dark of midnight as the transition is happening. And I just really see that as so critical, and I guess I didn't appreciate that until now when I heard you say that, so thank you.
There's very little to add to what you said. It's just, it's reporters do not like being surprised. And when they're surprised, they look for hidden motives. And when they find substance that comports with their suspicion, then you're dead. But if you're transparent about this, and by the way, and there was a couple really hard calls here. I remember specific occasions where I just asked Kendall to look at the file. And one I talked about recently at St. Thomas, at the symposium we had out there. It was a very high-profile case that was very important to certain segments of the Jewish community. And a rabbi friend of mine was the lead advocate for this particular person. And it was an ugly set of circumstances. So in that case, you're punished either way. You give relief, always trying to placate the Jewish vote for the next election. Or you don't, and then obviously you get all sorts of negative feedback. You got to stay away from that stuff. It's hard, and Greg's job is sort of to deal with it, at least from the press. But you're going to have situations, my friend, who had the dirtbag client, my great friend. You're just going to have situations where you just have to say no or yes. And because you know you're going to live with the consequences, not just, by the way, politically, but personally. I support capital punishment. 2 folks went all the way during my tenure. And you can talk about supporting capital punishment when you're governor and they explain the process to you, and you know you're the last person between life and death. That's heavy. So this is the kind of stuff that if you run for governor, you're overwhelmed by. Don't run for governor. But you have to really think about this stuff before you run, and you think about this stuff while you're in office. And so I do think, in this sense, my legal training and background helped prepare me to be prepared for the repercussions, for bad press, for people who might misinterpret an action. Just some thoughts.
I really love this idea of a pardon clinic, and I was wondering, first of all, were commutation decisions more difficult?
Oh, absolutely, sure. Because most of the pardons, you saw with Haley's, most of them are easy, and most of them are not. And few people are going to be interested in something that's 20, 30. But you sort of have this hierarchy. Was it DUI 30 years ago? DUI 15 years ago? DUI 7 years ago? DUI 6 years ago, and the guy who drives the bus for a living, and school kids, you start adding facts, and it makes it more difficult.
And are you considering helping people apply for commutations through your clinic?
We see a very practical aspect of this clinic. In the best of all worlds, I would love to house my operation at a law school that would allow students to have a very hands-on, proactive approach. We would take a limited number of applications, walk them through the process, state, federal, and give some law students some, not just some practical experience, but also help somebody, potentially. So I would see a very practical application here as part of our process.
First of all, thank you for your service. I've been in Maryland as well, and I appreciate your time and all this. Quick question, you talked about the Willie Horton thing.
Yes?
One of the problems is, I think the public sometimes, especially the media, like to pounce on a politician when they get it wrong. You know, if you commute somebody and they go out and do something heinous the next week. Is there some way that it can be part of the process to say, you know, we're not God, we can't always get it right, but we're trying to do the best we can?
Man, you want to cause problems for yourself? Let's say I'm at a podium as governor and I'm commuting a life sentence. And I understand what you're saying. I'm saying how difficult it is to practice. And words come out of my mouth to the fact that I'm commuting this guy. I think he's innocent, but he was accused of double murder. But I think that the facts are such that maybe we need to commute. And I really hope I'm right. See ya. I'm not sure the press would report that so far. I think you might have a heart attack. Look, I think we did some really good stuff. I didn't view it as particularly brave at the time. I said I view it as part of the job. But I'd also be lying to you if I didn't once in a while wake up thinking, what about this decision? And you're human. The president will tell you he does it. Governors will tell you. If they tell you, by the way, someone tells you that a president or governor tells you that they do not have those thoughts, they're lying, or they're sick, one or the other. But I just think that, again, you do the best you can. I think internally, that's the process. But you have to be really careful because your first job as governor is public safety. First. So if you're talking about fiscal repercussions or, geez, I'm really trying hard here, that does not vest you with sort of credibility you need as a strong executive.
Want to entertain just one last question, if there's one last question?
Yes.
My name is Anthony Edwards from Celebrities for Justice.
Yes, sir.
When your time in office, you mentioned educating people on the process.
Yes.
Did anyone from your office or yourself educate like the public, like your constituents, on the cases that you were looking at?
Sure. Oh, absolutely, because, and that's part of the political/communications process. Particularly innocent parts, and particularly those that really cried out for justice. And sure, you would talk about it because you want to influence public opinion. Absolutely. And the easier the case, the better in that regard. But you're not going to shy away from the tough ones either, or this process doesn't work. The tough ones make this process work. But every opportunity you get to make a point to the public that will be reported along the lines of the way you want them to think, you take advantage of it, absolutely. And that's not just being a smart politician, it's a smart leader. Thanks, everybody. Good luck.
Again, thank you so very much, Governor Bueller, and your 10 excellent points were really good food for thought. We want to transition for a moment to the panel, so can we have the panelists and the moderator take their seats? Okay, I have the honor right now of introducing the moderator of this very distinguished panel, American University Professor Jeffrey Crouch, whose research focuses primarily on the Constitution, the presidency, and separation of powers, and is the author of The Presidential Pardon Power. Among other courses, he has taught the American presidency, the presidency and the executive branch, and the mass media and American politics. With that, I would like to bring forward Jeffrey Crouch.
Thank you very much. Thanks to ACS and OSF for putting together this great panel, this great show today on this really important topic. Just to give the audience an idea of what we're going to do over the next hour or so. I'm going to talk about clemency in the big picture, a little bit about the history, how it got into the Constitution in the first place. And that'll take about 5 minutes, and I'm going to go through each panelist and give them about 5 minutes to talk about a particular subject of their expertise. And then we'll discuss questions amongst ourselves for probably 20 minutes or so, and then the last 10 or 20 minutes we'll open up the audience for questions. So let me begin with a brief overview of clemency. We're talking about federal executive clemency here, so we're talking about the president's pardon power. The reason there is a pardon power in the first place is because of South Carolina delegate to the Constitution Convention, John Rutledge. He is the person who's credited with raising the idea of pardon power. He took the Virginia plan and actually scribbled it into the side margin. And so that was the first appearance of pardon power at the time. And the most famous defense of the pardon power in the months and years after the Constitutional Convention was made by Alexander Hamilton, who of course is one of the co-authors of the Federalist Papers. And his famous Federalist paper is number 74. And in number 74, he made two key points about what the framers had in mind for the pardon power. First point I'm going to quote here, Without an easy access to exceptions in favor of unfortunate guilt, justice would wear a countenance too sanguinary and cruel. Basically what he's getting at there is there's no way you can make a perfect justice system. There's always going to need to be exceptions, and the pardon power is a way to remedy situations where the law is too harsh in a particular case. There's another famous phrase from Federalist 74, and that is, and I'm quoting again, "In seasons of insurrection or rebellion, a well-timed offer of pardon to the insurgents may restore the tranquility of the Commonwealth." So there's not just this purpose for clemency in individual cases, there's also a larger public welfare interest. The idea that clemency can be used to put down a rebellion, encourage people who are rebelling to come back to the country, and that came in handy pretty early on. President Washington, of course, used the pardon power to put down the Whiskey Rebellion, and other presidents used it after that. Clemency is in Article 2 of the Constitution. Article 2, of course, has the president's powers. The president has the power to grant, quote, reprieves and pardons for offenses against the United States, except in cases of impeachment. One of the limits that's implied there is that only federal crimes qualify. If you break a state law, you need to look to your governor or your parole board for a pardon in that case. When can the president pardon? Right away. There's no need to wait for someone to be indicted or charged, no need to wait for trial, sentencing, any of that stuff. As soon as the crime is committed, the president has the power to use the pardon power right away. Clemency is a check and balance power. As a political scientist, I feel like I have to talk about this aspect of it. Clemency is the president's check on the federal judiciary. If there's a decision that he doesn't like, the pardon power is his way to make that decision change. The president, in turn, is checked by Congress, by the impeachment power and the power of Congress to amend the Constitution. And Congress, of course, has the ability to do a number of things indirectly, things like threatening to cut off funding, delaying the president's nominees for office, issuing subpoenas, holding hearings, and all that good stuff. The forms that clemency can take, this is a little bit confusing because if you look at the language of the Constitution, it says reprieves and pardons. Those are actually just two forms that the federal executive clemency power can take. The most complete form of forgiveness is a full pardon. That basically means that the crime is forgiven. The next step down is a commutation. A commutation is basically where the punishment is reduced. In a lot of cases, we're talking about someone who has a prison sentence. The sentence is reduced. That person can leave prison earlier than they had planned. Remittance of fines or forfeitures. If you owe the government money, the government can say, we'll forgive that. You don't have to pay us. A reprieve is just a delay of whatever the punishment was. There's no lessening of it. And finally, an amnesty. An amnesty is basically like a pardon, but only given to a group. This is a type of pardon that's given for a public welfare purpose. So if you think about after the Vietnam War, amnesty was offered, and going back through time, there were amnesties offered after the Civil War and other times as well. The president has a bureaucratic entity within the Department of Justice to assist with clemency applications. It's called the Pardon Attorney's Office, and we actually are fortunate to have a former pardon attorney on our panel today, so I'll leave further discussion of that to her. One of the things about clemency that people sometimes don't really understand is how often it's used and the purposes it's used for. One of the questions earlier mentioned some of the more infamous pardons in history. Bill Clinton pardoned Mark Rich, Richard Nixon was pardoned by Gerald Ford, George W. Bush commuted Scooter Libby's sentence. These are the exceptional cases, and I think that's something that's going to be driven home as the speakers address clemency today. The exceptional cases are not the norm. What we're talking about today is the way that clemency could be used as a normal part of the administrative process, the way that it has been in the past used as part of the normal administrative process. If you look back through history, you'll see that FDR used clemency thousands of times, and his successors, in a lot of cases, used clemency hundreds of times. In recent years, George W. Bush, over 8 years as president, pardoned 189 people and commuted 11 sentences. So far, President Obama has pardoned 22, and he has granted 1 commutation. And that commutation went to Eugenia Jennings, and we're fortunate to have her brother, Cedric Parker, here today to discuss that in a few moments. And we'll talk in general about why clemency is down today. So we're going to talk about Obama's 1 commutation. We're going to talk about whether there are ways to encourage President Obama to use the clemency power, even more than he has, in particular in the context of addressing drug sentences. So without further ado, I'd like to briefly introduce the panelists. We are joined by former pardon attorney, as I mentioned earlier, and clemency specialist Margaret Colgate-Love, seated down there, as you can see. ProPublica senior reporter Daphne Linzer. We have University of St. Thomas School of Law professor Mark Osler. We have ACLU senior legislative counsel Jesslyn McGurty. And we have, as I mentioned a second ago, Eugenia Jennings' brother, Cedric Parker. And so I'm going to start with Ms. Love. Margaret Colgate-Love is a former pardon attorney, as I mentioned before. She served from 1990 to 1997, and she currently practices law in Washington, D.C. She focuses on executive clemency, restoration of rights, sentencing, and corrections policy. She has written several valuable articles about these subjects, including one that I would like to mention by name called The Twilight of the Pardon Power. And in this piece, Ms. Love considers how pardoning practices have changed through the 19th and 20th centuries, leaving us with the situation that we have today where hardly anybody receives clemency. And Ms. Love argues that much of the responsibility for clemency's decline stems from changes within the Department of Justice during the late 1970s and early 1980s that have encouraged the pardon attorney and the pardon attorney staff to neglect its responsibilities. So Margie, can you take a few minutes to address what is not working correctly in the Department of Justice? And can you describe how the process worked when you were pardon attorney, please?
Sure, thank you very much, Jeff, for that very interesting background information. When I knew you were going to ask me to talk about how the Justice Department works, I got to thinking that I should just say a small word about how it used to work and how it worked in the golden age of pardoning, which was the 19th century. And actually, we have here today, right sitting in front of me, George Lardner, who is writing a history of the pardon power. And George knows all about the golden age. Pardoning was big business for the presidency, and it was big business for the Justice Department. It was a very ordinary part of the job. I was so struck by Governor Ehrlich's phrase, part of the job. It was part of the president's job. It was part of the Justice Department's job. Executive clemency was very much sort of integrated into the justice system. We didn't have any early release mechanisms in the 19th century. Paroling was way down the line. So pardoning, far from being a kind of an extraordinary, unusual event or a political event, was very much sort of a part of the meat and potatoes daily business of the executive. When I got to the job in 1990, which is now seeming to me to be a very long time ago, pardoning had ceased to become a real ordinary part of the justice system. There were a lot of mechanisms that had been developed over time that took pardon's place. And so by the 1980s, there was very little pardoning going on. There was actually very little need for pardon in a funny way. The Justice Department had kind of taken its stewardship of the pardon power and kind of tightened up. It was still a very regular process when I got there. However, in the presidency of George H.W. Bush, it was treated with respect, and even though in the corridors of the Justice Department there were sometimes nervous jokes about pardon me and all that kind of thing, people sort of had a sense that this was an important power, and that the Justice Department had a very important role in making sure that the president was protected. And that, of all things, I just want to stress that the Justice Department was steward of the power and worked for the president. And I always regarded myself, even though I was a Justice Department employee, as working for the president and for the presidency, to make sure the president didn't make any terrible mistakes. Now, things changed in that regard. after I left. And I think if the one thing, I don't necessarily take responsibility for taking it with me either, it was happening. The sense that the president wasn't interested, the sense that the president didn't really want the protection of the Justice Department, and the sense that the Justice Department really had its own agenda in keeping the pardon power from being used in a kind of ordinary way. The agenda of prosecutors in the department really kind of was inconsistent with the agenda of clemency. And so what happened, I think, it's fair to say, at the end of the Clinton administration, when the Justice Department was basically not there for the president and let him do a whole bunch of stuff that really got him into very bad trouble, the Justice Department's pardon process was basically closed. And in fact, it literally closed at the end of the Clinton administration. It literally told applicants for clemency, don't come here, go to the White House, which was a really amazing thing to have happen. Sad to say, George W. Bush did not change things, did not pay attention, did not have a sense that Governor Ehrlich was talking about pardoning being a part of the job. Let the Justice Department more or less keep doing business as usual, which basically was just say no to pardon applicants. I would just sort of summarize and wrap up here this little memory lane trip here. What happened to the pardon process? The Justice Department did stop seeing its job as protecting the president and serving the president. It also stopped seeing its job as sort of helping applicants for clemency. Believe me, that is a big thing, because most applicants for clemency don't have lawyers, that don't have a lot of money, and sometimes they're not able to get access to the kind of information they need. And so I think the sense that the Pardon Attorney's Office staffed cases for applicants for clemency has really been lost. And I can tell you there is a hostility there that is quite worrisome to me. The Justice Department even stopped serving its own interests. And we have now increasingly been talking about taking the authority and the responsibility away from the Justice Department. So I would say that in closing down the process and making it so unhelpful to the president, in a sense, the Justice Department has shot itself in the foot, because it may lose what it has had for over 150 years. So that's kind of what has happened, short course.
All right, thanks, Margie. Let's move on to Daphne Linzer. Daphne is an award-winning senior reporter for ProPublica, an organization that does investigative journalism in the public interest. And she recently wrote or co-wrote several articles that were co-published with the Washington Post on the president's pardon power. She looked closely at the George W. Bush administration and combed through a mountain of largely unreleased data and looked for some general patterns. And what she found has surprised a lot of folks. So, Daphne, what are some of the major things you found through your research?
Thanks, Jeff. I'll take you through it. We did examine pardons that were issued during the Bush presidency, mostly just because it was a complete data set that we could examine after the president left office, and because President Obama's pardons are in flux and his numbers are changing all the time, we weren't kind of able to set it aside and examine it in the same way. So I'm going to tell you a little bit about our findings. Having looked at who the applicants were and who was pardoned and who was denied, we found that whites were nearly 4 times as likely to be pardoned than all minorities combined. This is after we weighed for sentence, offense, location, the age of sentence, the age of the applicant at the time of the offense, the applicant's gender, their marital status, their economic status, We used some proxies, such as whether or not they had liens against them, owned their own homes, had ever filed for bankruptcies, which the Pardons Office says they take into consideration, and whether or not the applicants had prior or subsequent offenses. Most of the people who applied didn't get far enough in their application to warrant the Pardon Office seeking an opinion from a prosecutor or a sentencing judge. But where they did, and we learned of as many opinions as we could, we weighed for that and also adjusted for that as well. In raw numbers, it's a little starker. 12% of whites who applied for pardons were granted. Less than 1% of African American applicants were successful. In fact, they had the worst chances of getting a presidential pardon. 199 people were pardoned by President Bush, and just 7 were African American. And that, statisticians will tell you, that is not evidence that black applicants can get through. That is statistical proof, basically, that they cannot. 1 Asian American was pardoned, and that was only because an associate White House counsel in the Pardons Office plucked that person out of a very enormous denial batch. Otherwise, there would have been none. The other thing we looked at of interest in this room is we FOIA'd all congressional communications with the Pardons Office during the same period to see if members of Congress were interested in advocating for applicants. Were they advocating only on behalf of donors? Who were they advocating on behalf of? And how much did that help? So an applicant with congressional support is 3 times as likely to be pardoned. We didn't do this for commutations, but anybody could. The thing about commutations, and we can talk about that a little bit more, is there have been 12 in 12 years. That's it. So it was sort of hard to gauge how much congressional support really matters. Of those 12, that includes Scooter Libby. Many of the people who did have their sentences commuted did have congressional support, but it's just a teeny little pool to look at. But members of Congress are interested in supporting applicants. During the Bush administration, 126 Republicans, 70 Democrats wrote to the Pardons Office in support of applicants. We cross-referenced that entire stack of names and applicants with campaign finance data. So we were able to determine when members of Congress were only advocating on behalf of donors, something the Pardons Office doesn't look at, but they do care very much about congressional support. They say it doesn't matter, but statistically it matters almost more than anything else other than race. The other thing that mattered a lot was marital status. The Pardons Office views marital status as a sign of stability. So if you're married, you're twice as likely to be pardoned. I guess if no one proposed, you are unlikely to be pardoned. Very unlikely to be pardoned. I'll take you through a little bit more, I think, later in our discussion. Some of the real stark standout findings that mattered to us a lot when we were able to determine the race of applicants. And this goes into, again, very stark language differences used by attorneys in the Pardon Office who are there today, who are going through applicants, the same exact attorneys who, for example, in documents that we found, an African-American applicant with children born outside of a marriage was chided for it in writing, and those children were described by lawyers who are in the Pardons Office today as illegitimate or born out of wedlock. Successful white applicants with the same family situation were described in the same recommendations, positive recommendations, as having children from a previous or non-marital relationship. We found similarly situated white and black applicants, same crime, although in every single case, the minority applicant was had slightly sort of less offender, had a less harsh sentence, but in each case, the white applicant was pardoned and the minority applicant was not. Minority applicants who had filed for bankruptcies, protection in this country, were rejected because they filed for bankruptcy specifically. We saw many successful white applicants who filed for bankruptcy, some more than once. We saw African American applicants who acknowledged in their applications that they owned a gun illegally. In fact, in many of these cases, these were applicants who were specifically applying for pardons because they had come to understand that they were illegally possessing a gun. They lived in states that had issued them gun licenses, and they wanted to sort of have permission now to own one, which you can after you've been given a pardon. They were denied specifically for owning a gun illegally. White applicants were forgiven in the same circumstance for not knowing, forgiven and excused for not knowing. One successful white applicant was pardoned even after the FBI determined he had lied to the FBI agents in his background investigation and interview, and that he had lied to the pardons office about the fact that he owned a gun. So we saw very, very different stuff, both in terms of statistics and language on race.
Thanks, Daphne. Mark Osler is a professor of law at the University of St. Thomas School of Law in Minneapolis, Minnesota. He's a former federal prosecutor who has seen firsthand how inflexibility in sentencing and corrections often has real and unfair consequences for the accused, especially in the context of cocaine offenses. At St. Thomas, Professor Osler has started the only law school clinic focused on federal commutations in the country. His students work directly with federal prisoners, reviewing their cases and assisting them with filing clemency applications. He also recently published a piece in the Federal Sentencing Reporter with Matthew Foss entitled "The Ford Approach and Real Fairness for Crack Convicts," in which the authors argue that former President Gerald Ford's Clemency Board could provide a model by which President Barack Obama could address the problem of crack cocaine offenders who are currently serving overly long sentences because they were not given any relief by the Fair Sentencing Act of 2010. Mark, could you talk a little bit about your proposal for a Ford-like clemency board?
Yes, thank you, Jeff. Thank you. This is an issue that does have a personal aspect for me. I was a federal prosecutor in Detroit in the 1990s. I convicted a lot of people of trafficking in crack, and I don't doubt that if the reforms that I'm arguing for today are imposed or enacted, that it's very likely that some of the people that I put in prison would in the end be the beneficiaries of it. However, since that time, as President Obama might say, my beliefs have evolved. And in a conversation with Margaret Colgate Love about what might be done about this, she mentioned the precedent of what President Ford did in looking at 100,000 draft evaders in the mid-1970s, and the social question of what to do with that large group. And it fascinated me once I looked at it more closely. I was teaching at Baylor University in Waco, Texas at the time. My co-author of the article, Matthew Fass, is now a prosecutor in Wichita Falls, Texas. So you have a commutation argument being made by a former prosecutor and a future prosecutor in that piece. What is fascinating about the Ford precedent and what he did is that most of us haven't heard of it. And that's significant because that means how controversial could it have been if it didn't make that much of an impact in a negative way. Certainly crack defendants aren't popular with the American public. Neither were draft evaders. Now, what President Ford did was significant. He set up an entire structure outside of the Department of Justice by executive order. He, through this executive order, created a presidential clemency board that was impaneled for 1 year and then would expire. There were 18 members of this board, and he relied heavily on people that had, who were prominent figures nationally. For example, Father Hesburgh of Notre Dame was a member of that panel. Vernon Jordan was a member of that panel. It was bipartisan, and it was largely composed of non-lawyers. What they set up was a process by which they could review the 21,500 petitions that they received. Of those, 14,500 were granted and given some form of clemency. One question that I'm asked sometimes is, well, would the numbers be greater if we're talking about doing something like this with crack defendants? And one thing to keep in mind is that the Fair Sentencing Act has already, and we're very grateful for this, changed the sentence, made it possible for people to have their sentence revisited if it was determined by the guidelines alone. Now, it did not affect people who had hit the mandatory minimum were sentenced pursuant to a mandatory minimum. And so that's who I'm looking at in terms of this. Now, of the people who applied for a break under the Fair Sentencing Act, there were 12,000 roughly who would be eligible, 6,000 applied, and 600 of those were found to be ineligible because of mandatory minimums. So we're talking about at most a number that would be significantly less than what the Ford Presidential Clemency Board had to deal with. They set up a process by which there would be staff reports on each applicant. The staff report would make a recommendation to panels of 3 from that board. There was a possibility of an appeal to the full board from that panel. They created standard aggravating and mitigating factors that could be considered. And in the interest of uniformity, they also created something called the Clemency Law Reporter that created a sort of common law so that people could refer to other decisions that were made by other panels. They also had a computer program, which in 1975 was pretty impressive, that would identify decisions that were out of the mainstream with what other panels were doing. The total cost of doing this and eventually granting 14,500 petitions was less than $8 million. And that was taken from the President's Contingency Fund. Now, of course, that was a while ago and there is inflation, but at that time it was less than 0.5% of the DOJ budget. So that may put it in greater perspective. This is a process that I think offers a very good model for what we could do to address those people who are affected by mandatory minimums, even in the wake of the Fair Sentencing Act. We're in a political setting right now where all 3 branches of government have said that the 100-to-1 ratio that between powder and crack cocaine that controlled these sentences is wrong. And to go back and to revisit those is just and fair, as all 3 branches have reflected. In conclusion, were we to engage in that kind of broad process, there's a secondary effect that's very important, and that is that for the first time in, for many of you, your lifetime, we would see a principled commutation process in which the principle is articulated first, and then action is taken in conformance with those principles in a broad, fair way. And the time is right for that.
Thanks, Mark. Our next panelist is Jessalyn McCurdy. She is a senior legislative counsel in the Washington Legislative Office of the American Civil Liberties Union. At the ACLU, she's responsible for defending civil liberties in Congress and in the executive branch in the criminal justice arena. Before joining the ACLU, she was a counsel for the U.S. House of Representatives Committee on the Judiciary Subcommittee on Crime, Terrorism, and Homeland Security, and she was the lead House counsel for the historic Fair Sentencing Act of 2010 when it passed Congress. Jessalyn, can you talk a little bit about what organizations like the ACLU have done to raise awareness of and to encourage commutations in the context of crack cocaine sentencing?
Sure. Thank you. I'll take you back almost 2 years now, actually, to the day or so after the Fair Sentencing Act passed. And as usual, I was either like sitting in Bobby Vassar's office, who was my boss at the time, when I worked for Congressman Scott and Congressman Conyers, or on the phone with Nkechi, and we were trying to think of, while we were still celebrating this great victory, we were trying to think of what's next. What would be the next step? Because what we knew was that the law passed in July of 2010, but it was silent on retroactivity in terms of statutory retroactivity of people who are currently serving crack cocaine sentences in the federal system. There was nothing specifically in the law that would address those people and getting fairness for those people. But what we knew was we had gone through a process a few years before in 2007 with the Sentencing Commission, where the Sentencing Commission actually took a very courageous step and looked, because of the unfairness in these crack cocaine laws versus the powder cocaine laws, they changed the sentencing guidelines to try to give some relief, to try to at least address this very unfair, what they had issued 4 reports on that said there's just no justification for this 100-to-1 disparity. And they tried to do what they could do within their authority to give some relief to crack cocaine offenders by adjusting the guideline, the base offense guideline ranges in 2007. So we knew that it was very likely that, at least the Sentencing Commission had the authority to look at the new law and change the guidelines based on the new law, based on the new ratio, 18-to-1 versus 100-to-1, and possibly apply that retroactively. And that was going to be a process that was going to come up over the next year or so. And it did, and it happened. And in June of 2011, the Sentencing Commission decided to apply their guidelines retroactively to adjust sentences for people who are currently serving prison sentences on federal crack cocaine charges. And as we know, many people have actually been released from prison based on those adjustments. But we knew that there was still, because the statute itself was silent on retroactivity, there would still be others that would not be able to benefit from the Sentencing Commission's retroactive application of guidelines. And so what Nkechi and I were talking about in terms of next steps back even 2 years ago was is there an opportunity for us to try to get relief for what the Sentencing Commission says is over 16,000, at least in 2010, was over 16,000 people who would not have an opportunity to benefit from the guideline change. And the first thing that came to my mind was commutation. The first thing that came to our mind was commutations. That is the next step in this process, is to try to figure out a process where we didn't know how many people it was at the time, but what we know now is around 16,000, probably, give or take, now that it's a year and a half later, 16,000 people, to see if there could be a process where they could try to have their sentences commuted based on an understanding, as Mark has said, by all 3 branches of government, that this law is unfair. And so that is what we are, several of us, Margie and others in the room, are sitting down and doing right now, trying to figure out, is there a way that we can figure out of those 16,000, is commutation a possibility in terms of trying to get them the relief that, for example, the 12,000 will eventually get. Now, let me say also those 12,000 that Mark points out that will get over 12,000 that will get relief under the sentencing guideline reduction will get relief over 30 years. So there are then people, again, there are people that have been released, but there are people who just had their sentences adjusted and are still in prison now and will be in prison for the next 30 years. So it's just a sentencing adjustment. So there's some category of people who even have benefited from retroactivity that we could think of still could deserve a commutation of some sort, depending again on their case, depending on the circumstances around their case. So we're really trying to, what we're trying to do is really in the beginning stages of trying to think through campaign, long-term and short-term, in terms of trying to identify cases, particularly cases of people who are crack cocaine offenders, and whether or not those cases would make sense that a petition for commutation could be filed and that we could, along with their family and others, support that petition.
Thanks, Jessalyn. Our last panelist today is Cedric Parker. He is a member of Families Against Mandatory Minimums, and he is here today representing his sister, as I alluded to earlier, Eugenia Jennings, the first and so far only recipient of a sentence commutation from President Obama. Just a very short background on Ms. Jennings. She was serving a 22-year sentence for a nonviolent crack cocaine offense because the law at the time disproportionately penalized crack dealers. While she was in prison, she finished school and she overcame her addictions to drug and alcohol abuse. Before she left prison, she was diagnosed with leukemia and today is hoping for a bone marrow transplant. And she lives with Mr. Parker in Alton, Illinois. Cedric, you testified in front of the Senate Judiciary Committee Subcommittee on Crime and Drugs in 2009 about your sister's abusive childhood and her struggles with addiction. What would you like our audience to know about your sister? And could you please also talk about her commutation and how it affected your family?
Well, I'm sure most of you are aware of her story, so I won't go into that. It had a huge effect on the family because she had 3 small children. So when she initially went to prison, I believe they were like 4, 5, and 1-year-old. So it was difficult for them as well as our family because they had to watch their mom grow up in prison. So there was really not a whole lot of communication because she was initially sent to Tallahassee, Florida. So because of that distance and my mom not being able to travel, they seen their mother, I think, once in her first 7 years of incarceration. I myself was in college and military, so I wasn't really around as well. So worked hard to try to get custody of her, which was difficult. My mom wouldn't give me custody. So it was kind of back and forth from wherever I was stationed back to Illinois to check on the kids. And then eventually I just got out and moved back to Illinois to assist my mom with the children. She didn't have a lot of money, as well as my mom not having a lot of money. So there again, federal prisoners have to pay to talk to their children on the phone. So the calls were very limited. So worked towards, while she was in there, she worked on her addiction, of course, and she started helping other kids. She was part of Scared Straight programs. She finished her education in prison. She worked a lot of hours just to have enough money to send to her children, you know, for birthdays, to send cards, Christmas, and things like that. Like I said, it's pretty difficult. So eventually she contacted me and introduced me to FAM. So I started talking with FAM. They're an awesome organization. And they helped a lot. And they did a lot of research on her case. And I'm sure a lot of people weren't too sure if she was really going to change, but she truly had changed. And I guess she convinced FAM that she had. So this has assisted her with working towards her possibly getting a pardon or commutation. During that process, it was still difficult, but she was moved closer to Greenville, Illinois. So once she moved closer, I was able to take her to see her children every week, which was good for her as well as them. And also during that time, she was eventually diagnosed with a rare form of AML leukemia. So as things were going good, it was one more thing, you know, for herself and the kids. So eventually she was granted commutation, released. She resides with myself, as well as her 3 children. And we pretty much take care of her. We have to take her to the hospital every day and test. So right now she's still looking for a donor. They have a new process they're going to try with a partial relative donor, which will be her daughter, who is now 18. And she received her commutation in November, and she finally came home the 21st of December of last year. So they wanted her home for Christmas and also in time for her daughter's graduation, which will be the 25th of this month. And once again, the commutation was good, you know, actually it was great. But I think once she got home, her children didn't understand the fact that when she receives commutation, it's a lot different than a pardon. So it's, she's home, but that's it. She still has to follow the rules as if though she's still in prison. She can't leave the state. She can't do a lot of things other people do when they receive their pardons. And I don't think they always like the idea of the parole officers coming through and walking through the house and visiting, but that's just part of the process. I just explained to them it's just good that their mom is home. So I think that's about it. Well, I also want to add that, I don't know if it's too early, but Senator Durbin, he was very instrumental, as well as FAM and other organizations like the Open Society and other people being really supportive. ACLU, American Bar Association, just everybody was great. And I just want to say he was very instrumental. He wrote letters, as well as other politicians wrote letters on her behalf. The state's attorney of Illinois, he wrote letters as well. And I'm sure that had a great deal to do with her receiving her commutation. So I guess that's about it.
Thanks, Sigrid. We have about 15 minutes for questions discussed amongst ourselves, and then we'll open it up for questions in just a few minutes.
My name is Charlie Sullivan, and my wife Pauline. Want me to go to the microphone? I don't think I need a microphone, but.
We actually, we're going to sort of talk amongst ourselves for about 15 minutes, and then we'll open it up.
About themselves.
So we'll.
Can I get a chance?
Yeah, just a few minutes, and definitely you'll be first up. All right, thanks. All right, so let's start with a big picture question here. Is there a role for pardon in the modern federal justice system? Is pardon playing the role effectively? And I guess, should the public care? Should the president care? Anybody?
Yes, no, and yes.
All right, next question.
No, let me say that I don't believe that pardon really should take the place of law reform. Pardon is an extraordinary remedy. On the other hand, when you get a situation like currently exists with the crack offenders, where so many people are still in prison serving sentences that everyone acknowledges are unjust, and where law reform seems not to be on the horizon, this is the classic moment where the president, almost using the pardon power in the sense that Hamilton spoke about seasons of insurrection, the sort of the political crisis, would step in and make a gesture toward those people. So this might, in fact, encourage law reform. And in fact, there's one very interesting case that Governor Ehrlich did, where he commuted a sentence which then had the effect of encouraging the Maryland legislature to change the law to cover other people in that class. It's a wonderful sort of historic use of the pardon power to send a message to the legislature. So yes, I do think that there is a role for pardon. I don't see that the pardon power is currently serving the role that it should, but I think unless and until the president gets a little more interested in his pardon power, it probably isn't going to happen.
Yeah, I would think it's important to emphasize that not only is there a role, and there should be a role, but I think in fairness, we have to recognize that there's political support for clemency in places where we may not expect. And the governor alluded to this earlier, that you can't do a very good job of predicting who's going to be for it and who's going to be against it. I speak to a lot of conservative audiences. When you're in Waco, Texas, that's pretty much who you have to talk to. And one thing that I think really rings true is that in the Constitution of the United States, you have this principle of mercy, that the President of the United States is handed that power of mercy. That is a Christian value that many conservatives can see as a part of the process. In fact, there's even an argument to be made that within our criminal law processes, there's a natural law impulse towards mercy. You look at the sentencing guidelines, 96% of the departures and variances are downward versus 4% upward. And even if you control for government recommendations for cooperation, it's 9 downward for every 1 upward. What does that tell you, given that the judiciary is composed of conservatives, liberals, everything in between, that there is an impulse towards mercy in the human heart? And that is something that this idea taps into, and it's very powerful.
Anybody else want to weigh in on that? Okay. I want to go back to something that Cedric said earlier. You mentioned that you had a member of Congress on your side. Is that a double-edged sword? Do y'all think that that can be helpful and harmful? And how do y'all feel about having a member of Congress sort of be in someone's corner when they apply for clemency?
I can talk just a little bit about the statistics. So, as I said before, certainly for pardons, an applicant has their chances of success were you know, they were 3 times as likely to get one if they had a member of Congress on their side. You know, that can be tricky. You know, the one thing that I did find in looking over a lot of documentation is, you know, when there is a conflict of interest, when an applicant is a significant donor that's not shared, not just with the Pardons Office, but the Pardons Office doesn't share that with the White House. And one of the things that I was sort of looking at in my series was how well served the president is currently by the Pardons Office in that process. You know, Margie may be able to talk more about whether or not that is designed to protect the president, so it's not a consideration, or whether that could blindside a president. But presidents certainly are often not told in a recommendation letter if there's any kind of conflict at all. But I kind of agree a little bit with Mark that there's certainly, members of Congress certainly are willing to do it. The one time when it could be, you know, not in your favor statistically is if you're an applicant and you happen to have a representative who's just not interested in writing a letter. You know, then you have bad luck. If you can't find somebody to write you a letter, if somebody's just simply not interested, then your chances of success go way down.
Margie? You wanna jump in?
Sure. Members of Congress have been interested in pardon cases for a long time, and it's perfectly appropriate that they should be as a constituent service and also as kind of a law reform impulse as well. It can be very, very helpful, and I think the Jennings commutation is a perfect example of it. It is the one commutation. It was a very good case, but I don't think that any of us who are familiar with it have any doubt that it was Senator Durbin's championing of that case and personal interest in the case that got it through. I wish that there were more members of Congress who were more interested in championing cases like that. I wish it weren't necessary. I wish the Pardon Attorney's Office was serving the president and was more interested in those who apply for pardon. Let me say one thing about the way the Pardon Attorney's Office is functioning now as far as the prisoner petitions, the commutation petitions are concerned. I understand that there are very few reports that describe a case that are going to the White House now. I always used to think it kind of my job, even if we were going to recommend against clemency, that we should describe the case in a way that the president would understand what he was doing, whether he would understand the facts of the case, so that it could be an intelligent decision, even if he was going to say no. I understand that the kinds of recommendations in clemency cases that are now going to the White House from the Justice Department do not have those kinds of factual recitations. They are basically a little more than names on a list. And I think that's a very short-sighted and unfortunate way of handling commutation cases. It does not give the president any idea of what he is doing, frankly. And I mean, if that's okay with the White House, I guess it has to be okay with us, but I don't know why it's okay with the White House. And I would hope that, I would hope that there would be some attention given to the kind of respect that is given both to pardon applicants and, frankly, to the presidency by the Justice Department in this process.
Anyone else? Okay. Let me direct one towards Jessalyn and Cedric. Could you talk a little bit about the ways that you can raise awareness of the clemency power? Like, what did Eugenia do to get the congressman's attention, and sort of how did that campaign get started? And you can weigh in from sort of the advocacy angle as well.
I guess from our angle, organizations like FAM and the Open Society, because I myself wasn't familiar with them, but there's actually quite a few prisoners who are very familiar with these organizations and they know who to contact. But I guess in a lot of the communities like mine, it's a smaller town, so we don't have all these different organizations that support the judicial system nor the community in most cases. So, I mean, it's going to take more organizations, I guess, to kind of branch out and go to these smaller areas, rural towns, or wherever, I guess, to get the information out. And you also have the issue with the individuals in the lower income areas. Really, a lot of them don't vote. They really don't care about what's going on the Hill, or a lot don't even know who their representatives are. So they don't know the first step to work towards that. So without that, you will never have that assistance of any politician, because I don't believe they're going to go to the town to ask everybody who needs help. So, I mean, I just think we need more organizations like these, and possibly, if they could, branch out to the smaller communities.
The ACLU has actually filed a few petitions over the past few years for two of our clients, one Hamida Hassan and another Kenny Lumpkin. And that's kind of unusual for us because, again, we focus a lot of our efforts on impact litigation, and so it was kind of an extraordinary step for us to actually take on these two cases, just in the context of our mission. But what we did in addition to that is tried to focus, and others on the panel can talk about whether this is good or bad in some context, media attention on the fact that we filed these petitions, on the fact that back in, I guess, the end of 2010, some of the groups here in Washington put together a campaign that they called Home for the Holidays. And part of that, most of that campaign was kind of a press or media campaign to talk about, for example, we focused on Kimba's case that Congressman Scott talked about, to talk about how she had been commuted, and Dorothy Gaines from Alabama, how President Clinton had commuted her sentence as well. And then also focused on other people who were currently still serving, particularly, again, the cases that we focused on were crack cocaine offenses that were still serving long sentences for crack cocaine offenses that deserved to be home, that deserved to have their sentence commuted. Ultimately, Hamida Hassan benefited from retroactivity. So she is either transitioning out of halfway house or has already transitioned out of halfway house in his home now. Kenny, we're still waiting on his, as I understand, he will not benefit from retroactivity. We're still waiting on a decision in terms of commutations. So one way that we have done it is focusing media attention on the cases, but I think that all depends on the individual lawyers in the case and whether they think that will be helpful, or in some cases it may be harmful. So,
very good. A question about the pardon process, and I guess our three middle panelists here are sort of experts on how the process works. Is it completely broken? Does it need to be reformed? Does it need to be moved outside the DOJ? What do you all recommend?
Yeah, it's completely broken. And I never thought I would hear myself saying this, but I do think it needs to be moved out of the Justice Department. There were a number of ideas that were floated early on in this administration, and you'll hear from Greg Craig, who was the White House counsel in the first year of the Obama administration, and he was very interested in figuring out how can we better protect the president, because both President Clinton and President Bush had not been protected by the Justice Department. And when President Bush told President Obama, soon to be President Obama, going up the hill in the limo, to pay attention, settle on a policy, and stick to it, I think that was very, very good advice. And so I think there are a variety of ways to administer the pardon power. And I think, the states, there are a variety of approaches in the states, from independent boards to to sort of gatekeeper boards, to various other kinds of administrative systems, and there are choices that could be made. But the main criterion, I think, is, you know, how do we make it easier for the president to do his job? And that, for me, is the main criterion.
I would agree that in the longer term, taking the pardon attorney out of the Department of Justice and having a different structure, putting that person in the White House or in the White House offices would make a lot of sense. And as Ms. Colgate-Love has articulated very well in the past, there's a problem with DOJ is a bureaucracy of prosecutors. And there's something in the psychology of prosecutors that makes it very difficult to give up on a conviction. And I understand this, having been a prosecutor, and I have a lot of empathy for it. Think about the role that prosecutors are put in our society. You're in a courtroom, you are looking someone in the eye and saying, I want you to go to prison for 20 years. And in our society, sometimes even, I think you should die. That is a wrenching process. And it certainly has a deep impact on someone when you are given the societal role of being the person who accuses. And it shouldn't surprise us that prosecutors are reluctant to let go when they've won. But what that means is that probably we should take this process out of that group so that there will be fairness and consistency in principle.
Yeah, I do, you know, I'm leaning toward Margie's conclusion about the viability of this process, of this current process. Because when you think about it, as several have indicated on the panel, you know, Eugenia is the one commutation that has been granted under the Obama administration, but there have been almost 3,800 that have been denied. And so you have to, I have to think, is the process that exists now a rubber stamp process of denial versus a real process of looking at these individual cases and making the decision, and that's just commutations, but making a decision on whether these cases should deserve, or these people deserve an opportunity to have their sentences reduced. So, I mean, I think it's a good question. I mean, if you just look at the numbers over the past 3 or so years.
So I'm going to jump in and be the stats person again. So you were talking about all the denials, and is it a rubber stamp process of denials? So in the last 4 years, 7,000 people have had their applications denied for commutations, which is an average of 7 every single working day. Ehrlich talked about how he had 2.5 people on this full time in the state of Maryland. At the federal level, there are 3 people who are paralegals in the pardons office that do commutations. So they're doing commutations full time, 7 denials every single working day, which is a pretty stunning output of work, especially when you consider that in the yes pile, there's been 12 and 12 years. You know, people ask me a lot since I started doing this series about examining the work of the pardons office and what can be done, you know, on the Hill, or how can it be examined a little bit more further. And I think if you start talking about taking it out of somewhere or moving it, it's worth examining how it operates at all today. And I would say that, you know, as far as congressional oversight, you know, there's a lot of things that could be examined. First off, the pardons office could be asked to keep statistics. They're one of the few places in the Justice Department that doesn't produce statistics, that has a completely opaque output and productivity as far as who is chosen for mercy and why. You know, some of the documents that I described that describe people of different races in different ways can be examined by Congress. You know, attorneys who write those documents can come and speak to members of Congress about why they made those decisions and why people weren't chosen. One of the things that the White House counsel looked at in the first year of the Obama administration was changing some of the regulations that the Pardons Office is currently using, like basically refusing to entertain an application from somebody who claims innocence. We heard Ehrlich saying that at a state level, that certainly occurs all the time. At the federal level, it really doesn't. And the Pardons Office is pretty upfront about it on their website, saying that such an applicant has quite a high bar before they would even look at the application. But in practice, nobody who claims innocence is pardoned, and nobody who claims innocence has their sentence commuted. And I talked to lawyers who served in the Bush administration and who served in the Obama administration who all believe that's wrong. So those are some of the things that can be examined. Those are Justice Department regulations. They're not law. They're not part of the clemency power in the Constitution. So those are all things that could easily be examined and reviewed, I think, when you're considering what to do with the Pardons Office.
Okay, thanks. We'll now move to questions from the audience for about 15 minutes. You, sir.
My name is Charlie Sullivan, and my wife Pauline and I started a grassroots prison reform organization called CURE in Texas 40 years ago. When we started with the bus service for families to the state prison. And we had a lady come in to buy a bus ticket at this little place across from the county jail. And she said she had just given $1,000 to an attorney, and he was able to get her husband up for parole. Well, in Texas, it's the Board of Pardons and Paroles, so whatever you say about parole, pardons, you say also about parole. But anyway, we realized then she had paid $1,000, she lived in a project, and in Texas, you automatically become eligible for parole once you serve 1/3 of your time back then. So basically, she lost $1,000. And so we focused for many years on the Board of Pardons and Paroles in Texas, so our experience brought us to the idea that really something that hasn't even been mentioned today, and maybe it's good, that really we're talking about money in regard to it. And when you mention money, you also mention attorneys. And my question is, like Pauline has said many times, and that the only cost of parole or pardons should be the cost of a postage stamp. It doesn't even cost that today. You have the internet. Right. They can go and file it. What, in regard to safeguards, are we talking about in regard to whether it is applying for a pardon with the Obama administration or teaching at St. Thomas or whatever? What safeguards are you contemplating to exclude money and attorneys?
Yeah, that's a really interesting question. Basically what the question's getting at is, how does somebody go about getting a pardon? And there's sort of this two-tiered system that's developed. One system is sort of the traditional way, which is you go to the internet, you go to the pardon attorney's website, you fill out the application.
The other way is the traditional way, is to go to the church.
Yeah,
Okay.
so that's one traditional way. And the other traditional way is, who do you know, who can you make donations to, and that sort of thing. And it's, there's definitely issues there. Somebody want to respond?
Yeah, I'd like to respond to that, Charlie. I don't think you are ever going to squeeze out influence from the pardon process. But the way that you can minimize it, and the way it has been minimized over our history, is to have a strong Justice Department administration that produces lots of favorable recommendations and encourages the president to use his power in a regular way. And that keeps the president out of trouble too. But I think as long as the Justice Department is unwelcoming to pardon applicants, commutation applicants or pardon applicants, they are not advocate anymore. As long as that is the case, then you are necessarily going to have the kind of phenomenon that you had at the end of the Clinton administration and the end of the Bush administration, where well-connected cronies, folks who can hire influential advocates, go straight to the White House and make their pitch. And it happened at the end of the Bush administration as well. It's just that President Bush was not as self-indulgent, frankly, as President Clinton was, and he didn't grant as many.
I'd like to ask that lady that did the research, how many that received the pardons had attorneys, had teams of attorneys? There are teams of attorneys ready. That's all they do and we're talking about the gentleman. If Sam was not available, would you have been able to apply for a pardon? No, I mean, and you represent the traditional way.
So I can tell you, the majority of people who got pardons applied without a lawyer. The majority of people got pardons. Now, very few people got pardons. 189 people got pardons. Lots of people applied unsuccessfully with lawyers. The question came up actually during the research, well, did they have good lawyers? Did they have Washington lawyers? I didn't really know how to quantify how good the lawyer was. But this city is filled with spectacular lawyers who have represented pardon applicants unsuccessfully and very frustratingly so, who believe they have wonderful clients who've taken on pro bono work. With so few applicants, believe me, nobody is making a spectacular living just representing pardon applicants because your chances are not great. But I think one of the things that has really frustrated people, and especially the attorneys, is that when the pardons office says no to their clients, they have absolutely no idea why, which makes it very difficult for them to sort of improve on an application, figure out what went wrong and how to try and do it again. So for the attorneys that I talked to, that has been a big frustration. It's not so expensive to apply, but it is definitely a self-selecting group. That was another thing that we realized when we were looking at the statistics. Somebody who applies for a pardon is somebody who has to conceive of the idea of seeking a presidential pardon. They have to have means to go to a website and find the application. They have to be able to download it. It has to be notarized. They need 3-character affiants. It's a lot of work. So there's somebody who's already quite motivated and self-selecting, which already puts them in a different category.
If I could just make one suggestion, I don't want to monopolize, I'm sorry. But one thing that we did in Texas and really pushed hard for, they had to sign an affidavit when they came to the Board of Pardons and Paroles on how much they were paid. And that at least, we had a legislator who would call and use his legislative influence, and like the person that worked at the port, is he calling as a legislator or is he calling as an attorney? So he had to put down what he was being paid. Is that available in research, how much an attorney is being paid to seek a pardon? Well, it should be. We should, if we're for sake of transparency, and then you could average that it costs so much to get a pardon.
But that's not the problem, Charlie.
It is the problem. It was in Texas, and I think it's still very much for the average person, it's the cost, and when you say cost, you also say the involvement of an attorney.
The problem, Charlie, is not attorneys. The problem is in the Justice Department. And they are not accepting applications with, well, I mean, that's the real problem.
All right, thanks for your question. Is there anybody in the media who would like to ask a question before we? Okay. Sir, microphone's over there if you'd like to project. Project, yes.
This is oversimplified, I know, but it strikes me that politicians, including the president, are reflecting public will in their positions and approaches to the issue of pardon, commutation, parole. In contrast, I believe, as you were mentioning, Mr. Crouch, in your introductory remarks, that these provisions for pardon, for parole, were put in our system as a reflection of public will. They were doing what they believed the public wanted done. So where's the disconnect? How do we get that back into the process? And I know it's very difficult to do a ground-up kind of thing. We want people to be like Governor Ehrlich, statesmen who are principled and politically courageous and all, and Yes, there are some, but they are very few and far between. So I have the concern that if we continue to put our focus there, we're going to have a long battle that is very difficult to turn. So have there been many indications of thought given to what it would take, if it's possible, I don't know, it apparently was at one point, to get the public involved? Because I really believe that if the leaders, the politicians, believed that they were accommodating public interests, this whole thing would be turned on a dime. So I don't know how to do it, but I'm wondering if our experts and the folks who are looking at it have given any thought to how such a process could evolve. Certainly it's not going to be short-term, but it seems to me if it can happen, that's the best way to turn this thing around.
Well, sure, and I think you're putting your finger on a really important dynamic here, which, Margie said earlier, it's the Department of Justice on up that's the problem. The president's not getting enough recommendations. It's a flawed process. I argue in my work that there's another dynamic going on as well, which is the president has access to the polls and has an idea, the public wants a tough on crime president, so where's the incentive for the president to stick his neck out for any little person out there? So you've got sort of the log jam coming from two different directions. So sort of with that set up, does anybody want to weigh in on that question?
Yeah, I will. I think that you're exactly right. That's one of the challenges that we face in trying to broaden the use of the pardon power. One of the things that has happened in the last few years that I think has been a great signal is that organizations like FAM, like the ACLU, have been putting the narratives of some of the clemency petitioners up on the internet, the stories themselves. And in starting the clinic at St. Thomas, one of the things that has become very clear is those human narratives are extremely important. That when we turn the corner from it being an abstraction, it being this person who sold crack, to being this person whose life is much more rich and complex, like your sister's, that's very significant. And I think that not only should we turn to the president and say, Mr. President, you should tell this story better, I think we need to take that on ourselves. And someone like Margie Love is excellent at that. I'm trying to train people to be good at that. It's an important legal skill, it's an important non-legal skill, and that's how minds change. Hearing the president talk yesterday about how he changed his mind about gay marriage, it wasn't he got argued into something, it's that his children came to him with a story. And that is how minds change, is in those still small moments, and that's really what we need to do.
I would just jump in and say, one of the things that an associate who worked for Craig looked at in the White House counsel's office was what they do in Virginia, what the governor does in Virginia, where every time somebody is pardoned, the governor's office actually does issue a narrative, kind of extolling the individual. The greatness of their rehabilitation and explaining sort of to the people why the governor made that decision, why that person is worthy. And I know that they saw that as a good example, as a way to sort of engage the public and demonstrate why somebody was worthy, and that changes a lot of minds.
And one of the things that I know that we've tried to do is, and I don't know whether this works, but in my mind, is make people understand that we're not talking about, particularly with our clients, we're not talking about people who've served 1 to 5 years. We're talking about people who have served many, many years in prison. How long was Eugenia in prison, Cedric?
Approximately 9 years.
Okay. But even for our clients, for Hamida, I think she ultimately served 18 years, between 18 and 19 years. And Kenny, I think, is now probably in that same range in terms of the years they served. So the point I'm trying to make, and I hope we're trying to make, is, kind of enough is enough. These people have served, they're not getting away with anything. They have served long, long periods and in the cases that we have represented, for very tangential and low-level involvement in these drug conspiracies that they got caught up with. It's kind of like enough is enough at some point.
And there are a lot of people who have long since served their sentences and are stuck on the collateral consequences of conviction, which there are hundreds and hundreds in every state and in the federal laws and regulations, where you can't get jobs and you can't do a whole lot of things. Your reputation is ruined and you are treated like a social pariah. Let me just say that I totally agree with Mark about storytelling. I think it is the critical part, and speaking as one of those dread lawyers, Charlie, that makes a living helping people tell their story, I find, and I don't charge people a lot of money, I think having somebody to help you tell your story is really, really important, and that's what I do. And I hope that if everybody in this room found somebody whose story was worth telling, and almost everybody has a story worth telling, and we could bring those stories to the president, he might well change his heart the way he changed his heart on gay marriage.
Thanks for your comments on that. In the interest of time, this will have to be our last question, so please proceed.
Thanks. Eric Sterling from the Criminal Justice Policy Foundation. I want to thank the members of the panel for not only your presentation today, but the work you've done over the years on this issue. We've spoken a lot about crack cocaine sentencing. We know that crack was mythologized in the 1980s, and in some sense it's sort of now been mythologized as the drug around which there's the greatest injustice. The title of our program has to do with the president's role in making drug sentences fairer, not just crack sentences. And I'd like the panel to address the injustices around other drugs. Crack cases are roughly 20% of federal drug cases. Do you have anything to say about the 80% of other drug cases, 80% of over 400,000 federal drug cases? Is there anything we're going to do about drugs like people who are sentenced to very long sentences? We know that these quantities, while they were tiny for crack, they're equally tiny for meth. They're tiny for LSD. They're insignificant for cocaine. They're modest for marijuana. 1,000 plants, 1,000 kilos of marijuana. In these conspiracies, lots of low-level people involved. Are there any comments that the panel has how to get the president to look on those issues in those drug cases?
So the question is, what do we do about other drugs, not just crack cocaine?
Well, and it's not just drugs, Eric.
Correct.
There's currently a proposal or actually it's now been approved, from the American Law Institute, Model Penal Code. 15 years is enough. Second look. You ought to take a second look at sentences after 15 years. Now, 15 years is a pretty long time.
That was the maximum under the Controlled Substances Act prior to 1984.
I think having a process that will fairly look at people who are in the prison system and who have been there and have gotten lost there. We've created a great system. We put people in prison and we can't find them anymore. They're gone. There is no way for them to come back to court. There's no administrative process, and the pardon attorney's office basically just says no. So that is the problem, and it is not confined to drug sentences.
Anyone else want to weigh in? Okay. All right, maybe we can squeeze one more question in. Please do. This is definitely the last question.
Okay, thank you. We talked about narratives, we talked about cases and stories, but I want to ask about the more difficult narrative, the cases that are not going to be impacted by this campaign that I think we're about to wage based on Mark Osler's article in terms of the class of crack cases that weren't impacted by the Fair Sentencing Act. What about those who have life sentences or might have multi-drug convictions that don't necessarily fall within that rubric? How do those stories get told? Stories where there might be guns involved, where there might be gangs, are those people also worthy of the clemency, the pardon power? Can you talk to us about that for a moment?
Just briefly. Absolutely. I mean, there's not a wall around crack when we talk about these things. In fact, the clinic at St. Thomas, one of the first 2 cases we took was a case that involved powder cocaine. It involved someone who, his parents were marijuana traffickers. He was kidnapped by a Mexican drug gang twice when he was 15 years old. And then he was involved in 2 minor narcotics transactions with his family, and then a 3rd one, and he got a life sentence. That's not a crack case. Again, the key there is the story and bringing that to the surface of what the background is. And you're exactly right, that there isn't a wall around crack, that those compelling stories exist in other areas as well.
Yeah, and sometimes the stories are not very appealing. I actually got a case yesterday, a 3 strikes case, where it turns out that the 2 priors, the first 2 strikes, were misdemeanors, and they were not perceived as such at the time the person was sentenced, and it was 22 years ago. So what do we do with that case, who has no access to the court, and he's serving a sentence that is a mistake, it's an error. And he's actually kind of not a very appealing candidate for clemency, to tell you the honest truth. But he's serving a mistaken sentence, and this is an error that needs to be corrected. And so, I mean, again, I know I sound like a broken record, but if there is not a place that people can go to tell their stories, and if we can't get the president to understand, like Governor Eric said, that this is a part of a job. A part of a job. It's a part of the job of being president, is to use the power and to listen to the stories. And, you know, that to me, to be able to get access with those stories is the most important job that we have.
I just wanted to follow up on Colonel Nkechi's question and comment. In terms of, for example, the numbers from the Sentencing Commission from 2010, the largest category of crack offenders that did not benefit from retroactivity of the guidelines were career offenders and armed career offenders. So that's kind of the question, like, how do we look at that just one category, for example? And I say we have to look at those cases individually to decide, because as we know, the career offender and armed career criminal statutes are, in some cases, as Marky says, 2 misdemeanors, a 3rd, whatever charge gets you into that category. So I think we have to look at those cases individually. The other category, largest category of crack offenders who didn't benefit were those who were sentenced to the statutory minimum. And I think those were some of the folks that Mark was talking about in terms of maybe the obvious that were already sentenced at the statutory minimum, so they couldn't benefit from a guideline change. So those are kind of the obvious group of people to focus on, but at least in 2010, that was over almost 5,000 offenders. Now, I'm not sure where you get your 600 number from. Was that another subcategory?
That's just what so far, according to the Sentencing Commission, people whose FSA motions have been denied because of
Gotcha. Okay, so that's good to know. And then there are others that have then here's another question. There are some that benefited from substantial assistance. They cooperated with prosecutors, and so their sentence was below the guideline range, and some instances below the statutory minimum. Should they benefit? Should they be up for commutation? Should they be someone that should be considered for commutation because they've gotten a reduction also? And then Nkechi talked about some that were convicted of both crack cocaine and other drug offenses. And then just some whose guideline range just did not change because of the recalculation of their sentence. Their sentence didn't change because of the guideline that they were at. And so I just want to give you an idea of some of the category of people that are out there that did not benefit and what their circumstances are. And those are the things that we are talking about and thinking about in terms of who we should focus on, who we should prioritize as we develop this commutation campaign.
Okay, that'll have to be the last word. We're officially over time. Thanks to my fellow panelists. Thanks to the audience. Thanks to ACF and OSF for hosting us. We will vacate the stage now. Thank you.
I want to thank the panelists for leading such a wonderful and compelling discussion. I thought it was great, and we're so fortunate to be able to partner with OSI to put on these types of programs and elevate the visibility of these really important issues. I'm with Sean Warren, the Vice President of Policy Development and Programming at ACS. Unfortunately, our President, Caroline Frederickson, could not join us today, but I know she'll be very pleased with the panel, and I just want to reiterate her commitment to these issues and also our organization as well. To offer additional comments on the pardon power before the program closes, we are fortunate to be joined by Gregory Craig. Mr. Craig is a partner of Skadden and Arps. In addition to his extensive civil and criminal litigation experience, Mr. Craig has spent several years in government service. Mr. Craig has served as a senior advisor to the late Senator Edward Kennedy and to Secretary of State Madeleine Albright. He served as assistant to the president and special counsel in the White House during the Clinton administration. Most recently, Mr. Craig served as President Obama's White House counsel. And while in that capacity, Mr. Craig advocated for pardon reform, identified ways to make the pardon process more attainable. Please join me in welcoming our next speaker, Mr. Greg Craig.
Let me begin by saying that I think it's just terrific that the American Constitution Society and the Open Society Initiative are sponsoring this conference. Let me also say that I thought that panel was absolutely terrific. I would like to pay special tribute to a couple of folks, in addition to Margie Love, who's devoted her entire professional life to the cause of pardon reform. I do believe that Daphne Linsner deserves a Pulitzer Prize for all the research and the work that she's done. This issue would not be getting the attention it deserves. And I've got to also say that to be the case about former Governor Ehrlich, who deserves a Profile and Courage Award for what he did, because without his record in office, we would have no example, no model to look up to. And he demonstrated that a responsible and robust exercise of the governor's powers to pardon and reprieve is actually part of the governor's duties and one of his responsibilities in office. Now, let me just say that the fact that Bob Ehrlich is a conservative Republican makes his example even more important, because I believe reform will not happen unless both parties embrace it. It is true, I think everybody here knows, that the politics of law and order is easy, and both Republicans and Democrats have banged that drum relentlessly in the past, sometimes with truly terrible consequences to our criminal justice system and the rule of law. Whether you are a Democrat or a Republican, it takes courage to be willing to be vulnerable to the charge of being soft on crime when you exercise responsibly and robustly the executive powers of clemency and commutation. It is shocking, just to begin at the highest level, it is shocking that so few people receive pardons or commutations. That is a problem in and of itself, because there are so many more people who need relief and who should receive this kind of relief that is contemplated by our founding fathers. But it is the disparity in the application of this power that is, to me, one of the most troubling aspects about it. The facts are clear. There's a great disparity in those who receive pardons, white versus black, rich versus poor. And perhaps even more troubling is the great disparity in the application of that power to the same course of conduct to individuals in similar situations, it is indefensible for citizen A to receive a pardon for what he has done when citizen B did something far less serious and was denied. Just like the creation of the sentencing guidelines was an effort to bring some kind of uniformity to sentencing, we should try to develop a mechanism. There should be some kind of effort to bring coherency and consistency to the pardon process. Now, I have 4 quick things I'd like to say about the enterprise that is the subject of this conference. The power that was given to the President in Article 2 of the Constitution to grant reprieves and pardons for offenses against the United States is as important today as it was 223 years ago when the Constitution was ratified and when Alexander Hamilton wrote Federalist 74, explaining the power of the pardon. We should look at this important component of presidential power not only as something that enables the chief executive to mete out justice unilaterally and individually, but also it should be viewed as a duty of the office. A president's performance in office should not only be measured by how well the economy is doing and by the jobs numbers and whether at war or at peace, but also by whether he has been responsible or she has been responsible in the exercise of this constitutional power. It is more than just a power, it is a duty and an obligation. The second point, we cannot improve or strengthen the exercise of this power, in my judgment, without taking it out of the Department of Justice. There is, at least perceived to be, in the Department of Justice, an institutional interest in preserving convictions and preserving sentences. The Pardon Office was created in 1893, and it was placed smack dab in the heart of the Justice Department. At the very least, there's a perception problem here. The DOJ is not perceived to be a neutral forum, an advocate for pardons or commutations. And the DOJ is not the place, and federal prosecutors are not the people who are seen as being reliable and unbiased in advising the President as to the exercise of this function. Whether there is something more than a perception problem here, I'm not qualified to say, but I do know that for Republicans and Democrats as well, the Pardon Office has not been successful in achieving what it was designed to do. My third point, I believe we cannot strengthen or improve the exercise of this power without taking it out of politics. So in pursuing reform, we must have Republicans as well as Democrats involved in the process. We must have the Federalist Society as well as the Constitutional Society. I have long been a proponent of the President creating a special commission to review the issue, to look at the performance of the Pardon Office, and to make recommendations about how to improve that. To me, this is the path to reform. I've also been a proponent for a long time about creating a special agency and independent commission, perhaps led by a panel of commissioners from both parties, and who have a large enough staff to do the work that is needed. This is the path to recovery, and I believe it could be done by an executive order, although probably an appropriation would be required from the Congress. My final point, the executive's power to commute sentences is every bit as important as her power to grant pardons. Commuting sentences takes much more courage, as we all know, because where granting a pardon usually involves a person who has already served his or her time, someone who has otherwise lived an exemplary life, someone who only wants to put the bad old life behind and remove the legal burdens of a felony conviction, commuting a sentence necessarily involves reducing a punishment, giving a lighter sentence to someone who has already been convicted of a crime and is currently serving a prison term. This is not an easy thing for a sitting politician to do, but it's part of the job. And everyone who is familiar with the system, whether it's the Chief Justice of the United States or your local magistrate, everyone who is familiar with the system knows that there is a crying need for a more pervasive, a more thoughtful, a more robust exercise of this function.
more action is needed to commute sentences by the chief executive. We all know, and I think you've probably discussed in the course of this conference, that there are literally thousands of individuals, people who have been given lengthy sentences for nonviolent first offenses, who will not be released for many, many years, but who should be released because the sentences they received were so disproportional to the crime. We all know that there is today a well-defined category of offenders whose sentences should be carefully scrutinized and perhaps modified for no reason other than the fact that there was an incredibly harsh disparity in the sentence that they have received, a great unfairness in the way the system treated two very similar, if not identical, courses of conduct. And so I leave you today with one last thought. I think it's unrealistic to think that we will ever fill the Rose Bowl with people arguing and advocating and marching for pardon reform. But we can make a difference, in my judgment, by working together, by the Constitution Society reaching out to the Federalist Society, by Republicans reaching out to Democrats. And I would close with the words that have been uttered by many, many disparate political leaders in our lives. I include Ronald Reagan, who said these words, George Romney said these words, Robert F. Kennedy said these words, and more recently Barack Obama said these words. If not now, when? If not us, who? Thank you very much.
We just want to thank everyone for coming. We have a big job ahead of us. I know I'm very inspired by everything that has happened today. Very intriguing concepts have come forth, and I'm ready to move forward and help make this happen. Thank you for coming.
Unless you are messing around with, natural gas derivatives, you don't have to worry about me.
Oh man, that's my hobby. I do that on the
I was at the St. Thomas Symposium. I spoke. So they.
Oh, okay. Mr. Walker?
I mean, we're almost ready. We're pretty much ready to go, but I don't want to file it because it's going to get done. So I've been discouraging them from,